All right. Okay, so this week in our reading, we are looking at some of the Federalist arguments on behalf of the Constitution. But what I want to do today is to consider another very important question concerning the Constitution, and that is not just the Federalist, anti-Federalist debate that we've been looking at, but the question of constitutional interpretation, right? Whatever its pros and or cons might be, and despite the opposition of the anti-federalists, the reality, of course, is that the Constitution was, in fact, ratified by the states in 1788, and since then has served as the law of our land. Today, however, we are faced with a question, and that is, given the Constitution that we now have, how is that Constitution to be interpreted? Right? The beauty of constitutionalism is that we, the beauty of constitutionalism, and more generally just any system of where you have rule by law rather than by men, is that the beauty of this system is that the Constitution is written and it's fixed. It's a fixed document that doesn't change except by a process of constitutional amendment. Yet, one of the limits of that system, of course, is that the Constitution and its laws must still be interpreted and applied by men. And so this raises the question of constitutional interpretation. Now, there are, in fact, many different theories of constitutional interpretation. And there are, but there are only two particular forms of which that I want to talk about today. One of them's going to be, is more familiar. One of them less so. The first is the theory that that you will either be familiar with or at least have heard of, and that is, and it's arguably the theory of constitutional interpretation that's most prevalent amongst conservatives today. And that is, of course, the Originalist theory of constitutional interpretation. So I want to talk a little bit about originalism, and then in the second part of class today, I want to talk about another theory, one that I think, like originalism, is worth our consideration. It approaches the question of constitutional interpretation from a different direction, and raises certain concerns or criticisms of originalism, and that is the theory of contractarianism. We're going to be looking at two different theories of constitutional interpretation today: originalism and contractarianism. Well, what is originalism? Originalism is the theory that the correct interpretation of the Constitution is the one that interprets the Constitution according to the text's original and public meaning, the original and public meaning that the text had at the time that it was drafted and ratified. In short, originalism is the view that what the text means now, or at least what the text ought to mean now, certainly for people like Supreme Court judges, originalism is the view that what the text means now or ought to mean now is the same as what the text meant back then. Okay. Now, originalism is not a new theory. In fact, you might say originalism is the original form of interpreting the Constitution. Originalists would claim that the framers and the ratifiers themselves originally, they understood the Constitution in originalist terms, and originalism comports with the purpose for which they were writing it. So there's a strong argument to be made that really the history of American constitutional interpretation has largely been an originalist one. So for example, if you go back to a very famous and influential work that you may have heard of or seen referenced, and that is Sir William Blackstone's commentaries, multi-volume commentaries on the law of England. These were published in the late 1760s, so we're looking at about 20 years prior, about 10 years prior to the Revolution, about 20 years prior to the drafting and ratification of the US Constitution. William Blackstone wrote this multi-volume commentary on the laws of England. So he's in England writing this body of commentaries on the laws of England. And it's really the first popular, written for laity commentary on the laws of England, very widespread in its reading, and really captures the thinking about law during this time, both in England and in America. And so Blackstone's commentaries, they embody the interpretive conventions that were in vogue in England and New England at this time, at least in the late 18th century. And Blackstone writes this. Let me give you a quote, a very brief quote from, this is in the chat box for our visitors. Blackstone says this: "The fairest and most rational method to interpret the will of the legislator is by exploring his intentions at the time when the law was made by signs the most natural and probable." Okay, so for Blackstone then, the aim of legal interpretation is to understand the sovereign's communicated will. And how do you understand the sovereign's communicated will? You look at what the sovereign actually has said. Okay, so Blackstone was essentially an originalist, and as I said, Blackstone's commentaries were widely accepted, widely read, and really expressed an era and how they viewed legal interpretation. But what about the framers and ratifiers? They also followed Blackstone's principles. In the Constitutional Convention, for example, the framers, right, we see some of this in the Federalist Papers, the framers extensively debated word choice. They took great care what words they used to express certain things. Why? Well, because they were committed to this Blackstonian conception of legal interpretation, which identified interpretation as a form of communication, and they saw the Constitution's text as the primary source of information that later readers would have as to its meaning. So the framers and the ratifiers, they understood that the Constitution, like other legal documents, would be interpreted according to the express language of the document. We see basically Blackstone's originalism being assumed in the Federalist and Anti-Federalist debate over the Constitution. It was basically a debate that was conducted along Blackstone's originalist principles. Brutus, for example, the most famous of the Anti-Federalists, he uses Blackstone's rules to argue that, for example, federal judicial power would empower the federal governments to swallow the states, right? So the Anti-Federalists, so looking at the text, what does the Constitution say, trying to understand it in terms of its original meaning and extrapolating from there, and in the case of the Anti-Federalists, drawing out certain concerns and criticisms they have about what it says. And then James Madison, founding father, gives a very clear expression of originalist theory in an 1821 letter that he wrote. Let me paste this in here for you. Madison writes this: "The legitimate meaning of the instrument must be," and here the instrument would be the Constitution, "it must be derived from the text itself. Or if a key is to be sought elsewhere, it must not be in the opinions or intentions of the body which planned and proposed the Constitution, but in the sense attached to it by the people in their respective state conventions, where it received all the authority which it possesses. All right. So in general, then, the early republic in the US was basically originalist in its approach to the Constitution. Now, this begins to change in the late 19th century and into the early 20th century. Won't go into the whole history here, but essentially what happens is originalism comes to be eclipsed during this period, during essentially the progressive era, late 19th, early 20th century. And this took place for a number of reasons. A couple that I will mention is during this era, you start to see a strong desire for a much more powerful federal government, one that isn't so restricted by the Constitution. And then also what's in the ascendancy at this time is Darwinian evolutionary thought, and it's affecting not only the sciences, but also, not only the biological sciences, but also social sciences and the science of law. And so what you start to see is Darwinian evolution-inspired conceptions of science now being applied to law, where law and the Constitution and its meaning is being seen as something that also needs to evolve. Society evolves, and the laws that regulate society need to evolve, and so that it's applied to the Constitution. All right, yeah, and so following the progressive era and through a good part of the 20th century, you see originalism starting to fade into the back, and that begins to change in the 1970s when, through conservative efforts, you see originalism beginning to enjoy something of a revival. Okay, well, I want to talk more about what originalism is. I think for a lot of us, particularly conservative Christians, we spend a lot of time reading the Bible and asking questions about what does the Bible mean, and we understand intuitively that our task in interpreting something like Scripture is we don't want to be guilty of eisegesis. We want to exegete the text. There's a message there that God has communicated in His Scriptures, and then our task as believers is to try to figure out what does the text mean, not to impose our own meaning on the text, but have the text meaning be imposed on us. So I think this idea of originalism is an intuitive and straightforward one for us as Bible believers. But right, the Constitution at the same time isn't the Bible. It's not the Word of God handed down to us, divinely inspired. And so what I want to do now is sketch a philosophical framework for how we might think about and how we might go about defending or articulating originalism as a theory of constitutional interpretation. And the framework that I'm using here is one that I'm getting from a recent book. This is by Lee Strang. It's titled Originalism's Promise, a natural law account of the American Constitution. And this is exactly what Strang is doing. He's developing what he describes as a natural law case for originalism. Okay? So he's trying to give a philosophical case for originalism. What is that philosophical case? It's a natural law case. Now, natural law ethics is something that we talked about a couple terms ago in our discussion of Aquinas. And just to briefly review what we said there, natural law ethics refers to the idea that moral norms, moral standards for human action are derived. Where do we get them? We get them from human nature and human ends. Moral human action is action that tends towards the realization of our distinctly human ends and our human functions, whereas immoral human action are those actions that serve to frustrate that nature, to frustrate our human ends. So if that's natural law ethics in general, what is meant by natural law originalism? Well, what natural law originalism says is that we can basically apply this concept of natural law that we apply to human action in general, and we need to apply it to texts in particular, and to the Constitution in particular. So how does that work? Well, natural law originalism says that the correct, or right, you might say, the moral interpretation of a text, right, the honest interpretation of the text, is the interpretation that makes the most sense in light of the end or purpose for which the text was written and received. Okay, so as the text of the Constitution was written, what kind of text is this? What was the purpose for which it was written? What's its function? Well, it's written as a law. Indeed, it's written as the foundation of all American laws. And so the correct interpretation of the Constitution on this theory is the interpretation that, in the first instance, interprets it as a form of law. And the correct interpretation of law is one that interprets it according to law's purpose. And the purpose of law is to secure, in the case of the United States, to secure the United States' national common good and to enable individual Americans to achieve their own human flourishing. Okay, so that's the purpose of law: promote American common good and the flourishing of individual Americans. So only this natural law interpretation of the U.S. Constitution both makes sense of our actual constitutional practice. Like, what is it that we actually do as we apply the Constitution in today's laws, as Congress goes about making laws, but making sure that it makes laws that are in conformity with the Constitution. And when the Supreme Court conducts its judicial review, when it evaluates laws that Congress has made or individual states have made to see whether they conform to the Constitution or not, what is that practice? What's going on there? What's being assumed or presupposed? And it's this view of the Constitution as a law that has been crafted for the purpose of promoting the common good and protecting the individual liberties, the liberties of individual Americans. And originalism, the point of natural law originalism then is to say, if that's the purpose of law, then the Constitution needs to be interpreted in light of that purpose, in light of that nature of law. And that when we look at what we actually do, this is the Strang's argument about this natural law constitutionalism. When we look at what we actually do, what our actual legal practice is, this natural law originalism helps make sense of that practice. Okay, so how does this natural law approach to the Constitution get us to originalism? Well, it gets us to originalism by means of what Strang calls the constitutional communication model. The constitutional communication model. And what this argues is that the original purpose of the Constitution was to facilitate communication first among and between the framers, right? As the framers are drafting the Constitution, what are they trying to do? They're trying to communicate with each other. The different individuals have ideas that they're trying to express to each other, and the Constitution is the product of that process. So the Constitution, its original purpose was to facilitate this communication amongst the framers, then between the framers and the ratifiers of the Constitution, as the different states and their government officers would read the Constitution needed to communicate the framers' meaning to them. And then what is more, the Constitution, the purpose of the Constitution is then to communicate from that original generation, the founding fathers, and their constituents, as well as to communicate to all subsequent generations of Americans. Okay, so even before, so the Constitution is a law, but even before it's a law, it's, or rather precisely because it is a form of law, the Constitution in its first instance is a form of communication. It's trying to convey a common message to many different parties. And it's this act of communication that the framers and ratifiers were trying to facilitate. Okay? So the Constitution, in short, was a product of and an intentional act of lawmaking. The framers and ratifiers, their purpose was to facilitate this societal pursuit of the common good and individual human flourishing. That was their purpose, and that's the nature of the Constitution. So to properly interpret the Constitution then, so this natural law originalist theory would argue, to properly interpret the Constitution, we need to see it in its first instance as an act of communication. And in order for it to communicate something to us, it had to first communicate something to its original writers and audience. And to understand then what it means to us, we need to understand what it meant to them. Okay, so that's a broad sketch of what, of originalism, and then what Strang is arguing for, namely a natural law argument for originalism. Okay, now I want to suggest a possible limitation of this natural law originalism. And today we're talking about two different theories of constitutional interpretation. It's not my purpose here to tell you which is the right one. It's rather to see that these two different interpretations embody different philosophical values, values that we've seen previously in this class, and our purpose is to set these side by side and ask about their relative merits or demerits. So I want to suggest now a possible limitation to this natural law originalism and use it to introduce a second theory of constitutional interpretation, namely that of contractarianism. Now, one of the limits of the above natural law originalism is this. If you're trying to hold the meaning of a text, and we're not just talking about any text, but now we're talking about a legal text, an authoritative text. If we're trying to interpret the meaning of this text according to its original purpose, much, of course, depends on the success of the original meaning of the Constitution. Right, the success of the Constitution to actually articulate a form of government that truly does protect the rights and liberties of its citizens. But here's the question: well, what if the original meaning of the Constitution is unclear, it's undetermined, or maybe it's just outright incorrect, right? So some famous examples here are if during the time of the framing and ratifying of the Constitution, slavery was a legal practice in the United States. And so if you're asking the question of, if the Constitution is written to preserve liberties of its subjects, and yet at the same time, this document is being written during a time when the liberties of certain subjects are not being recognized, namely slaves, and your question is, well, what is the original meaning of the text? And if the original meaning of the text is consistent with slavery, then then we have a problem. Another example would be the Constitution forbids cruel and unusual punishment. Okay, so cruel and unusual punishment is illegal under the Constitution. At the time of the Constitution, however, public flogging was widely practiced and not to be considered a form of cruel and unusual punishment. So if our understanding of the Constitution is limited to the original meaning of the text, that would seem to be an instance where the original meaning of the text allows for something like public flogging. So here's the broader issue, though. It's one thing to take a natural law, and here I'm talking more specifically about the natural law approach to originalism. It's one thing to take a natural law approach to things that God has made, right? That's what natural law ethics is doing, is it's looking at human nature not simply as this brute fact or secular given, but in the natural law tradition, it's typically understood that we're looking at human nature because human nature has been created by God for a purpose, and that's why the purpose that God has given to something has a kind of authority over that thing. And that's why we're able to derive moral norms from human nature, is because how God has made things to be is authoritative and normative for how that thing ought to act. When we're talking about something like the Constitution, however, we're dealing with something that man has made, and what men make, of course, in contrast with what God has made, is necessarily imperfect. So this leads to the second theory of constitutional interpretation I want to introduce. And here it's one that approaches the question not from the natural law tradition or natural law perspective of Aquinas, but now from the natural rights perspective of John Locke and the tradition stemming from him. Of course, this is a tradition that the framers of the Constitution were very familiar with and sympathetic to. So I want to suggest that this contractarianism theory of constitutional interpretation, that we see it as being rooted in the natural rights tradition of Locke. How so? Well, according to Locke, you will recall, human beings begin, at least theoretically, in a state of nature in which they possess complete freedom. It's not the freedom to dominate others, as Hobbes had argued, but it's a freedom to enjoy, it's a freedom from the coercion of others, a freedom to their own body and the produce of their own body and the use of their own property. So for Locke, human beings begin, at least theoretically, in the state of nature in which they possess complete freedom, and they enjoy all of their natural rights, such that the political conclusion that Locke drew from this is that the only legitimate form of government is one that is based on a social contract, whereby individuals voluntarily leave the state of nature and subject themselves to the government in question. And why do they do this? They do this so that they might better enjoy the liberties that belong to them in the state of nature, but because of the inconveniences of the state of nature, they end up being, their enjoyment of it ends up being too limited. Okay, so again, the point here is for Locke, remember, the only legitimate form of government is government that's rooted in the consent of the governed. All right. Now, so what happens then if we approach the Constitution from this philosophical perspective, and bear in mind that the entire Constitution was largely written from this perspective? Well, when we approach the Constitution from this radical consent-based philosophy, a slightly different theory of interpretation emerges. And this is what some have called the contractarian theory of constitutional interpretation. Here I'm drawing from the work of the legal theorist Tom Bell. So the contractarian approach, I guess one way of viewing it is, it actually advises that we, as we approach the Constitution and the question of how to interpret it, in some ways we need to actually forget, or it may be helpful to forget that it's a constitution. Why? Because if we treat it as this 200-year-old document with all the mystique and tradition associated with it, we miss something vital about what the Constitution is trying to do. Instead, contractarianism argues that we need to treat the question of interpretation the way we would treat any other legal contract. Okay, right? What is the Constitution? The Constitution is a legal document, and so when it comes to interpreting the Constitution, we need to apply the same norms that we would to any other legal contract. And in law, we don't always, to figure out how to apply or interpret a legal contract, it's not the case that we go to its original meaning, okay? Specifically, contractarianism says we should treat it like the legal document that the Constitution most resembles, which is what? Contractarianism would say that what Constitution is most like if you took the Constitution and you tried to compare it to all other legal documents that we have, what's the Constitution most similar to? And the contractarian's argument is it most resembles a standard form agreement that's being offered by a very large, powerful, unnatural person. A natural person just means not a human being like you and me, but an unnatural person would be like a corporation, okay, a company that's been incorporated. So the contractarianism reading of the Constitution says if we look at the Constitution and compare it to any other legal documents within the world that's governed by the Constitution, what's it most like? It's like a standard form agreement that's being offered by a large, powerful, unnatural person, think corporation, and that's being offered to its many relatively powerless individual subjects, okay? So, basically a contract that a corporation is offering to its customers, let's say. So similar to the natural law approach to originalism, contractarianism begins by identifying the function that the Constitution is supposed to serve. It's a tool, it's a social coordination device that we read as trying to promote peace, prosperity, personal freedom. And like natural law originalism, contractarianism would suggest that the right way to interpret the Constitution is the interpretation that best brings about the end which the Constitution exists to promote. So far, these are things that the contractarianism view has in common with the natural law originalist view. On the contractarian view, by contrast, the best way, they would argue, to achieve that end is by reading the Constitution not necessarily according to its original meaning of the text, right, the meaning that it had way back then, but to read it in a way that rather maximizes the consent of those whom it governs now. So that in this way, it maximally justifies the authority of the Constitution now. On the assumption, on this, right, Lockean natural rights tradition assumption that what justifies government, and therefore what justifies any constitution of a government, is the consent of the governed to that government and to its constitution. Okay? In other words, we need to read the Constitution in a way that maximally sort of preserves and respects the consent that's been given to it by its subjects. And the way to read the Constitution that maximizes this consent of those in whom it governs is to interpret it according to the same sorts of rules of construction that common law courts routinely apply in cases involving these standardized form agreements that allegedly bind individual consumers. Okay? So, in other words, the point here is that what the contractarian reading of the interpretation is pointing out is that there's a difference between how an originalist or any other actually school of thought might approach constitutional interpretation in the way that in our courts, in the common law tradition, the way we actually use contracts that are like the Constitution, we interpret them very differently. How do we interpret them differently? Well, what does this mean practically? Here are about let's see, six different considerations that courts use today in evaluating, when a contract binds two or more parties. One of the things they look for is the level of consent that was given to the contract. Okay, there's six different things that might be highlighted here. And here's what contractarians do is they take those six different things that courts look to determine the level of consent and how a contract should be applied to those who've consented to it. Contractarians are going to take these and apply it to the Constitution, and here's what they come up with. First thing that needs to be done is one must investigate the type of assent that can justifiably ascribe that you can justifiably ascribe to citizens. Okay, so in a contract law type of situation, you would look at the question of, okay, if this contract is to be held as binding on these parties, what kind of assent did they register to this contract? And so the contractarian theory is, all right, if we're going to try to understand and interpret the Constitution, one of the things we must investigate is what was the level of assent that the citizens, the subjects of the Constitution, have given to it. Is this something that they've in fact assented to? Second, a second principle is that in common law courts, you typically only enforce the part of the agreement or text that is plain, uncontroversial, and particularly clear. Okay, so if you have an agreement, the parts of the agreement that get applied are the parts that are uncontroversial, they're plain, they have to be clear. That's the second criterion. Third principle is any ambiguous phrases, if you have a contract and there's ambiguous phrases in it, you need to construe those ambiguous phrases against the drafter and in favor of those who are presumed to have assented to the contract. So you have one party who's drafted the contract, they presented it to another party. First thing we saw is that, okay, did the other party in fact assent to the contract? Second thing is if you need to enforce only those parts of the contract that are in fact clear, uncontroversial, and plain. Third, where there's ambiguity, you favor on the side of those who receive the contract and who have assented to it, and your prejudice is against those who drafted it. Okay, so that's just to protect the people who have later assented to the document from being imposed upon by deliberate ambiguities. Okay, if the drafter of the contract wants certain parts of the whole of the contract to be enforced, the burden is on them to make sure there aren't any ambiguous phrases, because if there are, what courts do is they rule against the drafter and in favor of those who presume to assent. That's third. Fourth, You need to protect the kinds of inalienable rights that the contractual document must be read to respect, right? So the contract, in order for it to be enforceable, can't violate any inalienable rights of the parties of the contract. That's the fourth. Fifth, you need to protect the reasonable expectations of today's parties. Won't go into that, but that's just another common contractual contract law stipulation. You protect the reasonable expectations of the parties today. Let's see. And then sixth, assess whether the document and its potential applications accord with fundamental fairness. This is just another legal statute that the document and its applications need to accord with fundamental fairness. Okay. So those are just some of the things that contractarians, they look to in contract law, and they see how are these contracts, particularly the standard form agreements that are often between very large, powerful corporations and comparatively weak individuals, and what are some of the principles that courts follow in interpreting these contracts to make sure that these weaker parties have in fact assented, and that they're not being taken advantage of. Okay, so the key tenet of contractarianism is to favor those readings of the Constitution that are prejudiced in favor of the advantages of the parties who are subject to the jurisdiction of the Constitution, namely the people who claim to govern it. And what this means is that, let's say you have a politician who adopts or enforces a constitution without regard to the meaning ascribed to it by the citizens. Such a politician would be held guilty of breaching not only his fiduciary obligations, but also the duty of good faith and fair dealing that they have to all the parties to a contract. So again, how is this different from, say, originalist interpretation of Constitution? There's some overlap and there's some important differences. Unlike originalist theories of constitutional interpretation, contractarianism focuses actually on the contemporary public meaning of the Constitution's text, rather than on the public meaning ascribed to the text at the time of its ratification. But here's where contractarianism is also very different from, say, non-originalist interpretations that we have today, because it favors the contemporary public meaning of those who assent to the Constitution over against the original meaning, both of the ratifiers, but also of the contemporary meaning ascribed to the text by latter-day judges. Okay, so contractarianism, like other non-originalist readings, favors contemporary interpretations of the text, but it's not the contemporary interpretation of, say, judicial activists on the Supreme Court or wherever. It's rather, what is the contemporary meaning given to the Constitution by those who are being for whom the jurisdiction of the Constitution reaches. So the argument then finally is that if we want to respect the consent of the governed, right, this Lockean principle, then we have to care what they, that is the governed, think when they read the plain text of the Constitution. Not what people long dead once thought about the text, or what judges and legal commentators now think. Now, we're going to be looking at one of the reasons for talking about both originalism on the one hand and contractarianism on the other is because for Wednesday and then for recitation on Thursday, we're going to be reading and then discussing a fascinating figure, Lysander Spooner, who basically at different points in his life was both an originalist and a contractarian. in his approach to the Constitution. Spooner was an abolitionist and pro-secessionist. He was writing during the time of the American Civil War. He was anti-slavery, hated slavery, but was in favor of the South's right to secede. So clearly for Spooner, the war, the American Civil War was not over slavery. It was over states' rights. It was over the right to secede. Prior to the Civil War, Spooner argued on originalist type grounds for why the proper reading of the Constitution ruled out slavery. Once he no longer felt that interpretation was working, he seems to have later moved to this a very different type of approach to the Constitution, namely a contract carrying approach. And what you're going to see in Spooner's treatise, No Treason, is basically a radical Lockean take on the Constitution. And his take is going to be that if the Constitution is to be binding on American subjects, then like any other contract, this is his contract carryism, he's going to apply how courts regard any other contract and apply it to the Constitution. And he's going to point out that in no other contract is the contract held binding in a court of law when the alleged party to the contract never consented to it. So we're going to look at Spooner as somebody who at different times seems to have adopted both of these views. And to bring this to bear, or to bring this to a point on a question that I want you all to be thinking about. So last week I asked you to consider the question, who do you find yourself agreeing with more? We have the anti-federalist criticisms of the Constitution, and then the federalist defenders of it. I asked you to just give some thought as to whose case seems more plausible to you, particularly in light of the last couple hundred years of American history. This week's question I want you to think about is whether we like it or not, the Constitution is what we have. And I think there's, even if you're critical of it, there's of course much to be appreciative of it. But here's the question: what approach to constitutional interpretation is best calculated to preserve the liberties of American citizens today? And this is an open question. Is it the approach that relies on what the Constitution meant back then, right? And from a pro-liberty standpoint, there's strong arguments for an originalist take on the Constitution, which is that the Constitution was a document that sought to protect the liberties of American citizens. And arguably did it, much better than, according to its original meaning, than how it's often interpreted today. But what approach practically to the interpretation of the Constitution is best calculated to preserve the liberties of U.S. citizens today? The approach that relies on what the Constitution meant then, or an approach that would rely more on what its subjects, its consenting subjects, or at least would-be consenting subjects, understand that Constitution to mean now and today? Okay, so that's the question. All right, we are out of time, so we'll end it there, and I'll stick around to chat with our visitors. So thanks all. We'll see you class on Wednesday.